Article 10 of the National Values, Article 118 on participation by the public, Article 1 on sovereignty, Article 2 and Article 124 of the Constitution. My Lord, this is not an attack on parliamentary autonomy. It is a defense of constitutional supremacy, and we proceed to demonstrate as follows. A procedural rule that makes meaningful public participation impossible is itself unconstitutional, however neatly drafted. The vice in Standing Order 64 is not merely that it provides timelines. The problem is that those timelines are constitutionally disabling. And I will demonstrate what Standing Order 64 provides. It requires, 1, the National Assembly's Speaker to dispose of an impeachment motion within 3 days of its notification. Thereafter, it provides the disposal of the impeachment motion by the National Assembly within a period of only 7 days. We have 339 members of the National Assembly who are supposed to dispose of the impeachment motion within 7 days. And lastly, it provides for transmission of the resolution of the National Assembly once they've passed the motion to the Senate within 2 days. The real vice falls under under Standing Order 64-2, where the National Assembly has only 7 days within which to dispose of the impeachment motion. This standing order compresses a matter involving reversal of several sovereign electoral choice into 12 days, thereby making meaningful public participation illusory. And where participation becomes illusory, Articles 10 on participation of the people being a national value and principle of governance is affected. And Article 118 on public access and participation is also affected. Article 2, my Lord, of the Constitution is supreme. Anything inconsistent with it is void. The standing orders themselves derive their authority under Article 124 of the Constitution, and therefore, they do not sit above the Constitution and cannot cut down constitutional obligations. The Supreme Court in Mate and another versus Wambora and another, 2017, the court held as follows. Courts have jurisdiction to interrogate even parliamentary standing orders for constitutional compliance. So this principle, my lords and my lady, answers any argument by the respondents of non-justiciability. This honorable court is being invited to supervise parliamentary politics. It is being invited to perform its constitutional duty of reviewing constitutionality. My lords and my lady, constitutionality is judged not only by text, but by purpose and effect. So we look at what is the purpose of Standing Order number 64-2. Its purpose is to force expedited disposal of impeachment motions. But what is its effect? In reverse, to restrict Parliament ability to facilitate meaningful public participation in the impeachment proceedings. With this, Standing Order number 64-2 has a purpose and effect that undermines constitutional rights and national values and principles of governance, and therefore should be found to be invalid. The petitioner specifically pleads this at paragraph 98 of its further amended petition. And that is the vice before this honorable court. My lords and my lady, impeachment is not ordinary parliament business, and that has been admitted by the respondents when they say impeachment is not necessarily a legislative process. It seeks removal of a directly elected constitutional office holder, and in practical terms, revisits the sovereign will expressed at the ballot. It is that serious. Such a process demands heightened constitutional safeguards, not reduced ones, like we have seen in Standing Order number 64. Yet Standing Order 64 does exactly the opposite, my lord. That inversion should then be found to be unconstitutional. My lord, I won't repeat what has been submitted before you on public participation. However, you've heard clearly that public participation conducted on the 4th and 5th of October 2024 did not meet the threshold of the principles laid out in the BAT case. This is the British American Tobacco Kenya PLC versus Cabinet Secretary of the Ministry of Health. And allow me to just point out what violations were made. And had we had more time, had the National Assembly provided for more time in its standing orders, perhaps they would have averted these particular violations. One, Mr. Swanya indicated of the no reasonable notice was issued. A notice of extension of public participation was issued on the 5th of October 2024, which was the last day and D-Day for public participation. There was no reasonable notice whatsoever. There was no informed participation. The people of Kenya were provided with information that was minus the defense by the first petitioner, where they had one-sided story for them to consider whether to impeach or not to impeach the second deputy president. There was no balanced influence. We've heard clearly that at Bomas of Kenya, participants were actually told that the forum was for invited members of the Orange Democratic Movement. That's ODM party. Members of parliament swayed participants during this engagement. We've heard that. Therefore, the process was partisan and violates the requirement of balanced influence. We've also heard of the no integrity or transparency because forms were unverified and cannot still be verified to date. No serial numbers on those forms that were used for public participation. No methodology was disclosed. And statistical anomalies such as 162.78% support in KO South was reported. Clearly, we will all agree that this speaks to constitutional fraud. Again, my lord, I reiterate, if the National Assembly had more than the 7 days required to dispose of this notice, this motion, impeachment motion, then perhaps these violations would have been averted. The respondents may argue timelines alone do not invalidate a process. However, our response would be not every short timeline is unconstitutional. So we might agree. But a timeline becomes unconstitutional where it makes constitutional compliance impossible. And that is the case with Standing Order number 64. Why do we say the timelines there are unreasonable? First, it allows no genuine civic education before participation, because the public participation was conducted by National Assembly. Second, it allows no adequate dissemination of relevant